I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what today is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? I'm feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. 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 And that's exactly what today is.
All right, y'all know what to do. It is that time. Shout out to everybody who's in the building, man. Good to see y'all in here. Hopefully everybody's doing well. Make sure y'all drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Let's go. Let's go. Okay, I think we're good. I see the 1s in the chat. Hopefully everybody's doing well. Let's see how we look at. Ooh, looking all crispy and clean on the screen. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, Classy Beats, classybeats.com, and today we're going to get into it, man. It's going to be another great day. We've got some more great news. Obviously, y'all know ASAP Rocky is free. He's out of there, but the journey is not over yet. We're going to get into that shortly. Also, we have some news. We're going to talk about some other things that are going on around the legal world, in the music industry world. We're going to talk about what's going on with TDE, and then we've got some more updates about, oh man, what's going on here in Fulton County. What a mess. But I gotta say what's up to the people before we get into it. Shout out to everybody who's in the building. Let me see who we got in here. Of course, we've got my awesome, amazing Amy is in the building. Shout out to Amy. I see the gang in here as well. Alabama Gigi's in the building. We got Michi, A Fitz, Les Cleaver, my guy. Power Folk Living is in the building. All right, we've got Valencia. Good morning. Shout out to Valencia. Shy Gal is up in here as well. Miss 86. Good morning, Trisha. We've also got, oh man, I missed somebody. Oh, there she is. Shout out to Libby 22 SC girl up in here. My guy Floyd, the real deal Neil, is in the building too. We've got, oh man, oh, shout out to Stylish Channel is in here as well. Our Stylish Chanel. Tanya Garrett's in the building. Shout out to Tariq is in here. James Johnson, good morning. Good morning. Good to see y'all, man. How are y'all feeling this morning? I know Rocky's feeling good after everything that went down last night. We're gonna get into it shortly. Good morning, Wondrous One. I Am Shout is in here too. Whew. That is crazy. I'm not gonna lie. I was getting all anxious and nervous, and I didn't know how it was going to go down, what was going to happen. I don't know if it was more because I didn't want to have to apologize and tell people, hey, y'all were right. or if I was nervous for ASAP Rocky, but amazing verdict he got last night. He got a second chance. So happy for him. So happy for his family. Hopefully he takes this and moves forward. And it's a teaching lesson, not only for him, but for the rest of his family. We're going to get into what it's going to look like for him moving forward into the future as well. If y'all could, please do me a favor. Make sure you like the video on your way in. If you haven't yet, it takes 2 seconds. It's free. And it lets the algorithm know that you guys are enjoying the show, and it shares the video with more people. Floyd said, my question up there was real. What did you ask, Floyd? I didn't see it. Let me see. He said, where is Relly? And when are they grabbing him for warrants? Don't wish jail on nobody, but the streets ain't safe with him roaming around, especially if you close up to a gun range and a Dunkin' Donuts. Dang. Well, we reviewed some of the interviews from Joe Tacopina last night, and Joe himself said, I think they should hold him accountable. I think they should charge him. I think they should lock him up. Now, the thing is, Relly was the state's witness, so they really don't have an incentive other than to make an example of Relly or to uphold the law, I guess you could say, in that instance when it comes to holding Relly accountable for what he did on the stand. But I mean, we all heard what Lewin said during his closing arguments. He looked straight at the jury and said, hey, listen, I know Relly got up here and he said that wasn't him on the phone calls. I know he said some other things, but let's be real. It was him on the phone calls, right? We all know that was him. And as Joe mentioned, they basically said, okay, well, perjury's okay. We don't have an issue with it. So how they're going to handle this moving forward, I don't know. I don't see them locking up their own key witness unless they just somehow want to make an example. But it's clear that Relly, he could be held accountable for that. So I don't know how it's going to go moving forward. Y'all have to let me know what you think in the comments and in the chat as well. What else are y'all saying? Y'all are saying good morning, good morning, good morning. Okay, let's go ahead and get into our coverage today. Now, I know they're going to say that I'm milking this, but I do not care. Shout out to ASAP Rocky. In case you missed it, we've got to run this video back one more time before we get into talking about the civil lawsuits, a couple civil lawsuits that ASAP Rocky is looking at facing from ASAP Relly and what that means for him moving forward. We got to run back the victory footage from last night's verdict. Here we go. And congratulations to Rocky again. Absolutely amazing.
Juror 4, look over her shoulder. So ultimately, I'm going to want to hear from all 12 of you whether these verdict forms reflect your individual true and correct verdicts. Everybody understand? All right. You're going to put these two in the morning.
This was a crazy moment, in case you missed it.
Juror number 1, are those your true and correct verdicts? Juror number 2?
Yes.
Oh man, come on, don't do this now. Hold on a second, y'all. Uh-oh, give me a second. And shout out to Tanya. Thank you for the super chat, Tanya.
Those your true and correct verdicts? Juror number 2?
Yes.
Juror 3 and 4?
Yes.
Juror 5 and 6? Juror 5, are those your true and correct verdicts? Yes. Juror 6?
Yes.
All right, let's get it. The verdict forms to Juror 7. Juror 8, look over.
Of course, I try and play this and the video's struggling. I think it might be me. Hold on.
Your shoulder. Juror number 7, those are your true and correct verdicts? Juror 7?
Yes.
Juror 8?
Yes.
9 and 10? Juror 9?
Yes.
Juror 10?
Yes.
11 and 12.
Yeah, me too, Kelbell.
Juror 11?
Yes.
Juror 12?
Yes.
All right, all jurors have stated that the verdict forms reflect their individual true and correct verdicts. Alex, read the verdict.
Yes, Your Honor. The Los Angeles Superior Court, County of Los Angeles. People of the State of California versus Joaquin Mayers. Case number BA 508142-01. We, the jury in the above entitled action, find the defendant, Joaquin Mayers,
Look at him breathing.
not guilty of the
There it is. Yeah, he was breathing hard.
Not get the audience. Or not get the audience.
Hold down, hold down. There's, verdict has to be read on count.
Repeat again, we, the jury. the above
Judge Arnold was probably
entitled
over there
action, find the
smiling.
defendant, Joaquin Mayers, not guilty of the semi-automatic firearm in violation of Penal Code Section 245, subsection B. A felony is charged in count 1 of the information this 18th day of February 2025, jury seat number 9, 4-person.
All right,
Title of court and cause. We, the jury, in the above entitled action, find the defendant, Joaquin Mayers, not guilty of the crime of assault with a firearm in violation of Penal Code Section 245,
Oh, man.
subsection B. A felony is charged in count 2 of the information this 18th day of February 2025, juror seat number 9, 4-person.
Joe looked at the jury and said, "Thank you, man. Hey, that's a great moment. Congratulations to Rocky. Hopefully he uses this for good, because this is definitely a second chance. I know we had talked about it. A lot of us were thinking this could go one or two ways. I had a strong feeling it was going to be not guilty, and I'm glad that is the case. Now, moving forward, Rocky is not done. He's not out of the woods yet, and I want to go through some of these pending legal issues that he has going on. Obviously, we know they're between him and ASAP Relly. I think we're just going to call him Relly from now on, because I have a feeling the ASAP is not going to be connected anymore. So the first thing we have is, initially, as we talked about in previous videos, Relly filed 2 lawsuits. Obviously, the lawsuit that was attached to the assault, which in this case, I don't know how that moves forward, especially since he's been found not guilty of the assault on both counts. And then the second one is the defamation case, which is a little bit more lengthy. That one's 39 pages, and it goes into detail about what Joe Tacopina was saying leading up to the trial, throughout the trial. And I'm going to be honest, we may see another amended complaint based on the interviews that Joe Tacopina did after this trial. We'll have to let Camille handle that one. I don't know how they're going to handle that moving forward. So they filed that defamation lawsuit, and then obviously it was up to Joe Tacopina Law Firm, and of course ASAP Rocky, who are all mentioned as defendants in this claim, to respond. So let's look at a couple of their responses here. So here's their first response to the defamation lawsuit, and let's see what they say. Defendant Joaquin Mayers, answering defendant, hereby answers the complaint of plaintiff Terrell Efron, we're just going to call him Relly, make it easier, as set forth below. General denial. Pursuant to California Code of Civil Procedures 43130, answering defendant generally denies each and every allegation of complaint, and specifically denies the plaintiff has been damaged in any amount or in any way as a result of any actions or omission of answering the defendant. Okay. First, affirmative defense. What are they saying? They're talking about the injuries, exclusive fault of third parties. The injuries and or damages complained of in the complaint, if any, were caused solely, directly, and proximately by the negligent or intentional actions or omissions of persons other than answering the defendant. Basically saying, hey, we didn't do it. All right. We didn't do it. Second, affirmative defense. Partial fault of third parties. The negligent and or intentional acts and omissions of third parties contributed to the damages complained of in the complaint, if any. Answering defendant is entitled to a judicial determination of the proportion of fault to those third parties and to a reduction of damages, if any, awarded in proportion to this fault. And then third, what do we have? Comparative fault or, oh man, I'm going to mess this up. If plaintiff sustained any injuries and or is entitled to damages under the circumstances alleged in the complaint or in any other respect, and said injuries or damages are wholly or in part directly and approximately caused by the plaintiff's own negligence, lack of due care and or fault of that or the plaintiff agents or employees. In the event that the plaintiff is found to have sustained injury in order to be entitled to recovery of damages, the plaintiff's recovery against answering defendant, if any, must be reduced by the proportion of damages caused by the acts and conduct of the plaintiff and the plaintiff's agents and or employees. All right. Also, they have the failure to mitigate damages as the fourth affirmative defense. The plaintiff failed to mitigate damages, if any, which Relly has sustained, and has failed to exercise reasonable care to avoid the consequences of harm, if any, in that, among other things, the plaintiff has failed to use reasonable diligence in caring for any injuries, damages, or property, failed to use reasonable means to prevent aggravation, there we go, of any injuries, damages, or property, failed to take reasonable precautions to reduce any injuries, damages, or property, failed to make any reasonable expenditures which could have been prevented the loss alleged, and otherwise failed to prevent the existence or extent of damage. Also, we have their additional defense, and here's what they're looking for. Wherefore, answering the defendant, the praise for judgment as to the plaintiff's complaint as follows. The plaintiff take nothing and obtain nothing by virtue of the complaint. Dang! The plaintiff take for cost incurred herein and for such other and further relief as the court may deem just or proper. And then that was signed by, of course, the attorneys for Rakeem Mayers, aka ASAP Rocky. We've got Robert Shapiro, Sean Riley, and James Sargent. All right, so that's the initial one. Then we have Rocky's answer to the defamation lawsuit. So this one's going to get actually pretty interesting, and it kind of is going to say the same thing, but let's see what they're talking about in this one. ASAP Rocky hereby answers the unverified first amended complaint of the plaintiff, Relly, dated on September 19th, 2023, or they're going to call it the FAC moving forward. And then they have a general denial, right? Pursuant to California Code of Civil Procedures 431, defendant generally and specifically denies each and every allegation of the complaint and each and every cause of action contained therein, and further specifically denies the plaintiff has been damaged in any amount or in any way as a result of any action of omission from the defendant. Basically saying in the defamation lawsuit, it's basically saying Rocky didn't do anything himself because Rocky hasn't really been speaking out about it. But Joe Tacopina, which was representing ASAP Rocky in this criminal trial, has been saying a lot in representation of Rocky, which is therefore Rocky saying it, right? So we know Joe, he's going to do his thing on this one, and I have a feeling he's going to fight this to the end. We'll have to wait and see. All right, what do they say? Failure to state a cause of action. The complaint and each and every purported cause of action therein against the defendant fails to state facts sufficient to constitute a cause of action or state a claim upon which relief can be granted. All right, their First Amendment, the complaint and each and every purported cause of action therein gives rise to no viable cause of action against the defendant. And as any statements defendant made regarding the plaintiff are protected by the First Amendment of the United States Constitution. Basically, he can go out there and say how he feels. Joe can say how he feels about the defense and their case and this criminal case being brought forward. That's not defamation. Interesting. What is the third? The truth. I have not seen this before in a response, but I love this. They said the truth. That is amazing. The complaint and each and every purported cause of action therein gives rise to no viable cause of action against the defendant. And any statements defendant made regarding the plaintiff were either true or made without the requisite degree of fault to trigger liability. And again, this is where the criminal trial could come into play. You have a prosecutor who clearly doesn't, oh man, I don't want to say this. In this case, I'll say clearly didn't care about the truth, didn't care about justice. He just cared about making sure they got a win. So much so that John Lewin was willing to go up there in front of a jury and say, hey guys, I know this man lied on the stand. Put that aside. Let's look at what actually happened, which is insane. Now we're going to the truth and saying that this same man is telling the truth in this civil lawsuit when he repeatedly lied on the stand and Rocky was found not guilty. I mean,
Stop the cap.
not a great look. No false statements, no false statement of fact. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the statements alleged to be defamatory are not false statements of fact. I mean, think about it. Think about it. Joe said that Relly was trying to extort Rocky and Relly was a liar. With Rocky getting this not guilty verdict, does that prove Joe's previous statements were true? Because Joe can now say, hey, listen, I said all these things about Relly. Look what happened on the stand. He lied. A jury found him not guilty. Why? Because Relly lied about what happened. You see the video, you see the scrapes on his hand. Everything I said about this man is true, and he's just trying to get a payday. He's not a victim. Dang. Statements of opinion. Here's the other part. It goes to the First Amendment as well. The complaint does not state facts sufficient to constitute a cause of action against the defendants in that the statements alleged to be defamatory are expressions of opinion. 6. Constitutionally protected speech. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the alleged defamatory statements of which plaintiff complains are related to a matter of public concern and thus are constitutionally protected by application of Code of Civil Procedure 425-16. There's no injury. Oh man, they said this boy's capping again. The complaint does not state facts sufficient to constitute a cause of action against the defendant in that the statements alleged relate to a matter of public concern and plaintiff failed to adequately allege that those statements concerning him caused the plaintiff any actual injury. His career was already over. That's tough. They said it can't be defamation if you don't have a career. Dang! Lack of knowledge of falsity. The complaint does not state facts sufficient to constitute a cause of action against the defendant as it fails to allege that the defendant broadcast the alleged defamatory statements with knowledge of their falsity or with reckless disregard for their truth. And again, I'm going to keep saying this. As we've seen in this criminal trial, everything that Joe said was proven to be true. And the jury backs him up there. We saw all the evidence in court. We saw John Lewin said, hey, this guy lied. It's fine. What else do you need? Privilege. The complaint and each purported cause of action alleged against the defendant gives rise to no viable theory of recovery against the defendant as the alleged statements are privileged by application of Civil Code 47C. There is also no oppression, fraud, or malice. Defendant alleges that the plaintiff is not entitled to recover punitive damages because he has failed to plead and cannot prove facts sufficient to support allegations of oppression, fraud, and or malice as required by California Civil Code 3294. Further, defendant committed no oppressive, fraudulent, or malicious acts with respect to the plaintiff, did not engage in this despicable conduct with respect to this plaintiff, nor did the defendant authorize or ratify any such acts. Again, Joe was just out there doing interviews and giving his opinions and his thoughts. Totally allowed, totally legal. That's what they're saying. Punitive damages violate the procedural and substantive due process. We're going to skip over that. We're going to skip over waiver. We're going to skip over this part. We'll go to the statute of limitations. This is interesting. The complaint and each purported cause of action therein is barred, and relief cannot be obtained based on any and all applicable statutes of limitation. I wish they would list what those are. And then they reserve additional defenses. We'll read that there. And then wherefore the defendant prays for judgment as to the plaintiff's first amended complaint as follows. The plaintiff take nothing and obtain nothing by virtue of the first amended complaint, the plaintiff's first amended complaint, and this action be dismissed in its entirety and with prejudice. That judgment be entered in favor of the defendant on all claims, that the defendant recover his cost of suit incurred herein, as well as attorney's fees to the extent permitted by law, and for such other and further relief as the court may deem proper, and that's signed again by ASAP Rocky's attorneys. And then they're showing that they served this via email, which is always interesting. And we have one more thing I want to get into, but before we get into this last piece, which is Relly's response to what Joe had to say on this one, I want to know what y'all think about this and just the civil suit in general. If you were to take a second and look at all of the quote unquote evidence that was presented during the criminal trial, if you haven't seen it, go make sure you check out the videos and check out the ASAP Rocky trial playlist so you can see what actually went on throughout the trial. Let me know how y'all are feeling about the civil case, looking at it from a civil aspect. Do you think this is something that could go through regardless of what the criminal case showed? Because in the civil case, as I mentioned before, and I want to make sure I read this, the burden of proof is just a preponderance of evidence, right? So it doesn't have to be like it is in a criminal case. It doesn't really focus on reasonable doubt. Is there a preponderance of the evidence? Meaning, is that possible? Is it likely that happened? When it comes to defamation, I don't know. This might be a tough one. And basically, do y'all believe it's more likely to be true? That's something you have to ask yourself as well. All right, then we have this. What do we have by Relly over here? He says the plaintiff Relly's opposition to defendant ASAP Rocky's motion to stay civil action pending criminal proceedings. So basically, they wanted to hold off. They went through a whole thing. Joe had a back and forth basically saying the only reason the criminal trial was in place in the first place is to help out Relly's civil lawsuit. And there was a lot of threats there. I'm actually not going to get into this one, but I'll leave the link to this full document below. Let me know what y'all think in the comments and in the chat. Man, how are y'all feeling in here, man? We got a bunch of people in the building too. I appreciate everybody that's in here. Thank all of y'all for liking the video as well. Over 50% of you have liked the video. I want to see what y'all think about this too. Let's see. Well, maybe you're right. I don't know about the law like that. I might need to read more about brandishing. Yeah. The threshold and civil suit is lower and easier. So he may be able to get something if he can prove he was blackballed and it's hard for him to make living. He can win. And that's what I mentioned before when we read the initial defamation lawsuit. That's going to be the toughest part of it, is showing loss of, what do they call it? Loss of wages or something like that. Saying that you lost money or you don't have as many opportunities, that's going to be hard to disprove. Because again, in the civil case, it's different, which let me read this. Preponderance of evidence means that the plaintiff must prove that their claim is more likely than not to be true. Essentially, that there is at least a 51% chance that their version of the events is correct. That's tough. I'm going to keep going. In some civil cases such as those involving fraud, defamation, or punitive damages, a higher standard of proof called clear and convincing evidence may apply. This requires the plaintiff to show that their claim is highly probable, but still falls short of the beyond a reasonable doubt standard used in criminal cases. Very, very interesting. Didn't really admit all his artists left him voluntarily. Yeah, but he's blaming that on Rocky. That's the thing. How does a pimp show his wages per month and what he lost yearly? You saying pimps don't get a W-2? Dang. He said it's hard out here for a pimp. They're just trying to get some rent money, man. I don't think this will fly. Relly will be asked some of the same questions to prove his case, and this guy can't keep his story straight. Ain't that the truth? He has told many lies. Let's see. The only way Relly will get anything is if he doesn't take the stand, but not sure there's enough if he doesn't. Well, if they didn't have the blueprint before, I'm sure ASAP Rocky's lawyers have the blueprint now. And they're going to be able to show all of the testimony from court, the inconsistencies. They're going to show, hey, he's been found not guilty on this. Relly is a horrible witness. He will have to testify again. He will crash out and lose again. They should just dismiss it. Now, he needs the money, man. I don't think. Listen, if you're looking at an opportunity to possibly get $30 million, or let's take it down to, what would that be? 1%, $300,000. I think you're going to take the time you need to see this through. So I don't know. We'll see. He tells unnecessary lies. The phone calls actually helped him, but he's so stupid he called them AI. I couldn't believe that, man. And what's even worse, again, the prosecutor, John Lewin's not getting anything from that $30 million that Relly would possibly win. He does not care about this civil lawsuit, which is why he went up there and was like, yeah, you know, he lied, whatever. We're not going to do anything about it. But what we do know is we got to hear the phone call. And as y'all mentioned, some people think that it actually helped the prosecutor's case, hearing the phone calls and saying, see, Relly was saying what happened on the phone, but I don't know. He was on the defensive, man. Think about those 30 M's. Your mind gets blurry, I guess. That's what I'm saying. Unless you're Tony Busby, are you putting him on the stand? Dang. Tony Busby catching strays. Well, he deserves it. Tony Busby's a piece of trash. Shout out to Tony. I mean, the court should dismiss it. We know he won't drop it. Yeah, dismissal is coming soon, I'm sure. People were mad. You're saying people were mad that Rocky didn't get locked up? Dang, that's terrible. I don't know why they would want to see him convicted. I guess the only reason I could see people wanting him to be convicted is two things. First thing being, Rocky should have never been there in the first place. This could have 1000% been prevented if Rocky would have just kept to himself, kept his cool, not tried to play tough and go and meet him, right? The second thing is, as we've heard reported by some people who spoke to jurors, that they believed it was a real gun. And again, this goes to the whole fear thing that John Lewin introduced. If it was a real gun and Rocky's just in the street trying to make Relly dance, that's so dangerous. So dangerous. So if you believe it's a real gun and it could have been easily prevented, I could see how some people would say, man, lock his butt up. He shouldn't have been out there in the first place being dumb. So I get it, but I would have to hear the reason people are saying that he should have got locked up. I personally don't believe it was a real gun. I don't get why people are saying the prop gun defense doesn't make sense to me, because if you're going to say that, those same people are also saying that the magazine that was found in his house did belong to him and it goes to the gun that he had, which it doesn't make sense that he would either forget it or he would keep the magazine and it had different ammo in it than Relly found. So I don't know. I would have to see what they said. They said he was guilty and that was definitely a gun and that Relly was being honest. Stop the cap. They felt bad for Relly. They said one of the jurors spoke and said they also believed Relly. Oh my. Well, okay. I mean, no judgment here. If they believe Relly, I mean, I'm not gonna say anything against him or hate him for it. I just don't see how his story made sense. Let's go ahead and get into this next part. Did I not have this? I thought I had a picture of this. Let me see. We're gonna do it this way. All right, here we go. And let me read a couple more comments. Y'all said, I had an elevator door hit my head, ceiling collapse, constantly hitting my high-end cars. Okay, I missed the context on that one. If you believe Relly, I have a bridge to sell you. I don't see how they could believe Relly's testimony. Culturally speaking, we know when ninjas are lying. There were no blacks on the jury. That's true. Nick at Night has a juror interview on her channel. Yeah, I shared it last night. I'm not going to review it here. I'm going to let her have her shine. I don't know. I'm kind of moving away from using other content creators stuff. Content, they'd be a little too sensitive. They'd be a little too sensitive. The prop gun theory makes sense to me because he is a celebrity and had already been in trouble. Yeah, a prop gun would scare a normal person and keep him from violating the law at the same time. I agree. I think it's a smart move. He said, I'm gonna be oh man, he said, I got itch. Really ran from the truth, and honestly, she said there were times there may have been truth there, but they did not believe him as a whole. I agree. I pray the civil suit disappears. Also said there's no proof either way if it's a prop or not. Common sense says it's real. He's got a carry permit. Yeah, but I guess the reason they didn't want to go the real gun route is because then you have to worry about someone getting harmed. But what I'm hearing reported is that a lot of the jury believed that the gun was real. So there's that part too. What happened to fair use? It puts their channel out there too. I hope they don't strike your channel, Classy A. Well, you know, we're going to talk about that over on the Patreon. I have had an issue with the content creator in the past. Probably not anyone that y'all know. So I'm just, fair use usually does apply, but if someone decides to take it to the next step, it's just a pain. And you can usually find the information you need without getting it from someone else's YouTube channel. So anyway, shout out to SBE Mo Money. All right, let's get to this next topic. I got Judge Whitaker up there because I don't have a picture of TDE. So shout out to Judge Whitaker on this one. So this is something I've been wanting to report on for a minute. We haven't been able to get to it because of everything that's going on with the ASAP Rocky trial. But recently, Kendrick Lamar's former record label, TDE, a lot of y'all know Top Dog Entertainment. We talked about it during the Drake and Kendrick Lamar beef. There's actually a lawsuit that came out against TDE. Now, we're actually going to get into the full lawsuit, break it down, and you guys will give me a chance, or you guys will get a chance to listen to it and come to your own conclusion and see what you think, if maybe it's something that's not making as much sense or it looks like it could be true. So let's go ahead and get into it. Shout out to Sound for this breakdown, kind of giving us a background on what's going on with this lawsuit.
In the midst of the Drake and Kendrick Lamar beef, Drake having his legal battle with UMG over Not Like Us, and a week away from Kendrick Lamar performing Not Like Us at the Super Bowl, now we got TDE, Kendrick Lamar's former record label, having a lawsuit alleging TDE, Top Dog Entertainment, the actual CEO, Top Dog, his two sons are in this lawsuit. They're being sued by two women. One of them was working there in 2019, and she's saying that Top Dog's son, Brandon, approached her with unwanted sexual advances and sexual battery, and that Top Dog's other son, which is known as Musa, Anthony, engaged in a pattern of ongoing sexual harassment. She also said that she wasn't paid for her professional services while they are at TDE working. The second woman is alleging that there was multiple instances of sexual harassment and assault by TDE employees in general while on the TDE property under their control. Then we have TDE responding with their lawyer. Their attorney today has responded. These women were anonymous Jane Does. TDE has now named the woman, Linda Luna, Aya Altari, and they're saying that the women demanded $48 million from TDE.
Sheesh.
$48 million were
Good
demanded by
Lord.
these women. TDE says that this is a clear example of a shakedown and fabricated claims. TDE says that they have text messages and communications. They have evidence that can refute these actual allegations. Also, they're saying that both of these women never even worked at TDE.
He got that ambition.
All right, so it's looking like this thing, they're already calling the BS already. It's lawsuit season. It seems like it's lawsuit season every month, but we're going to go ahead and get into it. But before I get into the breakdown of the lawsuit, we do have a response from TDE themselves. And here's what they say. All right. So Orange Davis Law and Brandon Banks Law file lawsuit against Top Dog Entertainment for harassment and assault. What do they say? Two women have filed a lawsuit against TDE and several of its executives and employees alleging assault, harassment, and breach of contract. TDE is an independent record label recognized for its contributions to the music industry, including its role in launching the career of Grammy-winning artists Kendrick Lamar and SZA. The lawsuit alleges a pervasive culture of harassment within TDE, implicating some of the highest ranking executives. The plaintiff, Jane Doe, who we now know has been named, who worked for TDE starting in 2019, alleges Chief Marketing Officer Brandon Tiff, and that's I won't go into that, approached with unwanted sexual advances and assaulted her. And that President Anthony Tiff Jr. engaged in a pattern of ongoing harassment. I'm trying to edit this, y'all, so bear with me just for YouTube purposes. The complaint also alleges that TDE failed to honor a contract between its president and Mrs. Doe to pay her for her professional services. Plaintiff Jane Rowe, a second survivor, alleges she endured multiple instances of harassment and assault by TDE employees while on a TDE property. And under their control, among the allegations is an incident in which she was coerced into consuming alcohol while underage for the purpose of exploitation. Sheesh. Despite being made aware of these incidents, TDE's leadership allegedly turned a blind eye to the misconduct, perpetrating the unsafe and hostile environment. The lawsuit presents a glaring example of the systemic abuse and exploitation in the entertainment industry, said attorney Shalnak D will say of Orange Davis Law. Our clients trusted TDE to act with integrity and professionalism. Instead, their trust was betrayed in profoundly damaging ways. They're bringing this lawsuit because they refuse to be silenced and because they intend to hold TDE accountable in court. The plaintiffs are seeking damages for emotional distress, economic harm, and violations of their rights under California law, as well as punitive damages for TDE's ratification of misconduct of its officer. So let's get into the actual lawsuit. Shout out to King Jared for posting the actual lawsuit here. We're going to read through this and see what actually went down according to them. First off, we have the introduction. The defendant, Top Dog Entertainment, we'll call them TDE, is an independent record label specializing in hip hop and R&B artists, best known for launching the careers of several prominent artists, as y'all know, Kendrick Lamar and SZA. Plaintiff Jane Doe was hired to perform public relations and marketing services for TDE. During the course of her performance of work for TDE, she was subject to inappropriate workplace behavior, including harassment and assault by officers and executives of the company. Moreover, Miss Doe, or Jane Doe, was not adequately compensated for the services she performed for TDE, which reneged on its contract for payment and refused to pay her what she was owed. Dang, y'all gotta pay your people, man. Plaintiff Jane Rowe, this is the second person, was a friend to one of the artists signed by TDE, hereinafter Artist A. In exchange for her providing moral support to Artist A, TDE provided her a room and board at the house owned by TDE that doubled as a studio. During her stay at the TDE property, Miss Rowe was harassed twice by TDE employees, one of whom gave her alcohol despite being underage in an attempt to further certain types of advances, we'll say. TDE's leadership knew about these instances of abuse, as well as the failure to properly compensate Miss Doe. So the friend that was hired for the marketing, yet took no action to prevent further violations, discipline the individuals involved, or offer supportive services for the plaintiff. All right, here are the parties. We've got Jane Doe, she's a California resident who performed services for TDE for 5 years through 2024. We've got Jane Rowe, who's the second person who was allegedly underage at the time, is an Arizona resident and was harassed by TDE employees for a year. It looks like 2020 to 2021 while living at TDE or a home owned by TDE. The defendant, TDE, is a California corporation. We know that. And then we have the defendants as well. Both of these are Top Dog's sons, allegedly. Defendant, one of Top Dog's son, number one. We also have David Harrell. He's an employee of TDE and resides in LA. The true names and capacities of Does 1 through 10 inclusive and are unknown to the plaintiff who sue. Well, we know who they are now, so we don't have to go through that. Let's just go through the factual allegations. Professional services and unpaid compensation owed to Jane Doe. What happened in 2017? We'll go to, I was going to say Top Dog number 2, but we'll say Mr. Tiff Jr. initiated discussions with Miss Doe about joining TDE to handle public relations and brand marketing in 2019. He formally engaged her services to work with Artist A, agreeing to compensate her at a monthly rate. TDE did not compensate Miss Doe at the agreed upon rate. Finally, in May of 2020, here we go. Defendant Tiff Jr. acknowledged the financial constraints had prevented him from properly compensating Miss Doe as he agreed, and instead offered her a co-management position for Artist A in exchange for 10% management fee. That is 10% of the total compensation the artist received upon signing a record deal. Miss Doe and Mr. Tiff Jr. agreed to this 10% would be considered for past uncompensated services that Mrs. Doe performed for TDE. So she said, don't worry about the money you owe me in the past. I'll take this 10% and we'll keep working, right? In March 2023, Artist A signed the deal with Warner Records for a multi-million-dollar figure. However, TDE refused to provide Miss Doe with the agreed upon 10% management fee compensation. Dang, y'all. We've got battery and harassment of Jane Doe. In January of 2021, Miss Doe was a victim of battery perpetrated by defendant Brandon Tiff. Defendant Tiff made unwelcome advances, forcibly removed Miss Doe's clothing, oh God, and attempted to forcibly engage in intercourse and other stuff without her consent. Clearly you can't be doing that, right? Gosh. Miss Doe was also subjected to ongoing harassment by defendant Anthony Tiff Jr. throughout her tenure providing services for TDE. This harassment included unwelcome romantic overtures. So he was singing to her? Is that what that means? What is a romantic overture? I think that means he was singing to her. Inappropriate comments suggesting she utilized sexual favors for professional gain, and the unsolicited sharing of explicit material, including a video of an individual engaging in intimate activities with another woman. Good Lord. Junior also used Mrs. Doe's home as a covert location at which to cheat on his partner. bringing various women to the home and engaging in intercourse with them in Miss Doe's guest bedroom.
That brother's starving.
Man. Assault and harassment of Jane Roe. So this was the one that was allegedly underage at the time. Jane Doe and Jane Roe. In late 2020, the plaintiff Roe, a friend of artist A, moved to California to provide her with moral support in her career. TDE considered this a valuable service. In exchange for her support, artist A, TDE provided Miss Roe with a room and board in a TDE-owned property. I wonder if this is standard practice for record labels. I know they'll do it for family, but if you just have a friend and you want your friend to come along with you, that's interesting to see if they actually do that. While residing there, excuse me, hold on. All right, we're good. While residing there, Ms. Rowe was subjected to multiple instances of harassment and assault by TDE employees. Oh, it gets worse. In November or December of 2020, a TDE employee known as B-Dog approached Ms. Rowe from behind in the kitchen and without consent rubbed his junk against her butt on 2 separate occasions. What? Come on, man. In January of 2021, defendant David Harrell was asked by artist A to drive Miss Rowe to the TDE studio. On the way, Mr. Harrell stated that he needed to stop at his home to grab some documents for Junior. After bringing Miss Rowe inside, he coerced her into consuming an alcoholic beverage despite knowing she was under the age of 21. Okay, so she was not underage. She was just under the age of 21. All right, I'm glad they clarified that because it's kind of confusing. After Miss Rowe had consumed the beverage, Mr. Harrell began taking off Miss Rowe's clothes without her consent and attempted to force himself onto her to engage in intercourse. Miss Rowe was able to escape and ran out of the home. Boy, this running out of the home stuff is interesting. What do y'all think about that so far? First cause of action, the harassment. The plaintiff hereby reallege and incorporate by reference all paragraphs above as if set forth in details herein. The cause of action brought by the plaintiff, this is going to be Jane Doe, against defendants TEE, Junior, and Brandon Tiff, and by plaintiff Rowe against defendants TEE and David Harrell. Okay, I think we already read through all this, but we'll double check and make sure we didn't miss any details. Of course, they've got battery in here as well. She didn't consent to touching. Jane Doe was harmed and offended by the touching. Y'all keep your hands to yourself, men. Men, keep your hands to yourself. Women, you can keep your hands to yourself too. But I don't know. Y'all have to talk to the men about that. A reasonable person in plaintiff Doe's situation would have been offended by the touching. Come on, man. At all relevant times, defendant Tiff was a managing agent of TDE. Defendant Tiff's conduct was ratified by defendant TDE, which had knowledge of said conduct, but took no actions to prevent it. That's why she's suing. That's why she's suing them as well. B-Dog touched plaintiff Rowe with the intent to harm or offend her. Oh, so he grabbed her up. He snatched her up. Like, don't you say anything. Plaintiff Rowe was harmed and offended by the touching. A reasonable person in plaintiff Rowe's situation would have been offended by the touching. And it looks like Amy's got the definition here. It says a romantic overture is a proposal or gesture that is intended to begin a romantic relationship. What? That's so weird. It's a proposal or gesture that is intended to begin a romantic relationship. Okay, so he was just asking her out, I guess. I've never heard that phrase before. We've got the assault, okay? Jane Doe did not consent to Tiff's conduct. At the relevant times, defendant Tiff was managing agent of defendant TDE. Tiff's conduct was ratified by defendant TDE, which had knowledge of said conduct but took no actions to prevent it. B-Dog used force in an attempt to engage in intercourse with the plaintiff Rowe, who was under the age of 21. Plaintiff Rowe did not consent to B-Dog's conduct. At all relevant times, B-Dog was an agent of defendant TDE. B-Dog's conduct was ratified by defendant TE, which had knowledge of said conduct but took no action to prevent it. We've got negligence. We know what this is going to be. TDE knew about it. They didn't do anything, right? By failing to protect plaintiffs from unwanted and harassing conduct by TDE's employees and managing agents, TDE breached its duty. All right. And then we got the final 2 pages here. Of course, we got the breach of contract. They didn't pay her. TDE failed to compensate the plaintiff. Under the terms of the contract, the plaintiff was therefore economically harmed. Oh, dang. As she was not financially compensated for the time, effort, and resources she spent performing her contractual services. And then they say, here we go. Wherefore, the plaintiff prays for judgment against defendants as follows. For actual and compensatory damages according to the proof of pursuant to all applicable laws and regulations. For civil and statutory penalties available under applicable law. For pre-judgment and post-judgment interest. For punitive damages for an award of the attorney's fees, costs, and expenses as authorized by applicable law. For such other and further relief as the court may deem just and proper, and for trial by jury on all causes of action so triable. And that is signed by the plaintiff's attorney. What do y'all think so far? Are y'all believing this story? I'm going to say innocent until proven guilty. But listen, being in the corporate world, you hear this story a lot. So I'm still going to hold to my innocent until proven guilty. It'll be interesting to see how TDE responds to this. If they show certain text messages, maybe there was something there and the plaintiffs aren't being fully honest in this claim. We'll have to wait and see. Y'all let me know what you think in the comments and in the chat. Wow. Yeah, I got to see a little bit more too. I'm with you on that. I'm like, because a workplace, dealing with this stuff in the workplace, it can go one of 2 ways. And most of the time it doesn't go very well. Floyd said, sending love to all the women in professional settings who deal with these monsters. Hope y'all get the justice and closure that's needed. Yeah. I wouldn't want to have to deal with that. Innocent until proven guilty. Y'all are saying, okay, so we're still on that. I like it. Lord, I sure hope these attorneys vetted this and didn't take the word of another firm. Oh, Tony Busby is catching major strays today. Shout out to Ryan S. Oh man, he was asking her out or saying unwanted things about dating her, complimenting her, etc. He was just trying to get with her. So is there a limit on how many times that you can ask somebody out without them saying no? What did they, I want to go back and see. What is romantic overtures? I want to see what the legal definition is. Let's see if we can find it. Romantic. So we're seeing that there's no really legal definition of it. It depends on the context. Family law, workplace harassment cases, or criminal proceedings. General definition. It's basically what Amy said, right? A romantic overture typically refers to an act, gesture, or communication intended to express romantic or amorous intent toward another person. This can include verbal expressions, compliments, flirtation. So you can't compliment? Dang. Yo. Listen, y'all better go to work and just be done with it. No friends, no hugs, no high fives. Go to work, keep your head down, clock in, clock out. Compliments, written messages, love letters, or text messages, or actions, giving gifts, asking for a date. Yeah, don't do this at work, y'all. Just wow. Obviously, the context, the legal context, harassment, workplace, or school. If the romantic overture is unwelcome and persistent, it may be considered harassment under the laws like Title VII of the Civil Rights Act and Title IX for schools. Repeated romantic advances would be an example, despite clear rejection, may be classified as hostile work environment harassment. Okay, so you get one. All right, you get one. You get one, guys. So according to this, no, again, this is not legal advice. This is not legal advice, but according to this, it sounds like you get one. So if you get rejected, you shot your shot and you missed, okay? So, and I guess this goes for ladies too. I should say guys and ladies, keep it fair, right? Stalking or unwanted advances. This is when it goes to criminal side. If the overtures involve repeated unwanted communication or gestures that cause fear or distress, they may fall under stalking or harassment laws. For example, repeated unsolicited love letters that make someone feel unsafe and constitute criminal harassment. This is wild. Family law, divorce or custody cases. In a divorce or custody case, evidence of romantic overtures might be used to prove, might be used to prove adultery, infidelity, or improper conduct. So these are the different instances or contexts that it can be used. That makes sense. Contract law, breach of promise to marry. In rare cases, listen to this, a romantic overture that leads to a broken engagement might become relevant in a breach of promise to marry lawsuits. What? Breach of promise to marry. Boy, oh boy. They do think of everything, huh? We can't get the family court systems right, but they thought of breach to promise to marry. Yo, that is crazy. Have y'all, I've heard of the idea, but I've never heard it put in a legal term. That is insane. What? I gotta read this again. A romantic overture that leads to a broken engagement might become relevant in a breach of promise to marry lawsuit. Oh man, we might have to go down the rabbit hole. What the heck is a breach of promise to marry lawsuit is a civil claim where one party sues another for breaking off an engagement after the party making a promise to marry. These lawsuits were more common historically, but have been abolished or restricted in many U.S. states. What state does it apply? That's what I want to know. And I've heard of this before too. I've heard several instances where this was used. If you're this is crazy. Dustin says there's 1 million females in this country. I don't need to hit on women at my job. Shout out to Dustin. Just go to work and go home, man. Dang. A clear and definite promise of marrying is existed. The defendant broke the promise without a valid reason. The plaintiff suffered damages as a result. Oh my gosh. Damages in a breach of promise case. If successful, the plaintiff might be awarded damages for emotional distress, compensation for humiliation or mental suffering, financial losses if the plaintiff incurred expenses in the preparation for the wedding, loss of social standing. Historically, a broken engagement could harm a person's reputation, especially for women. Restitution of gifts. The return of engagement rings or expensive gifts might be ordered depending on the circumstances. It's abolished in most states, still recognized in which states? Wow. Ryan said, I must have never watched Judge Judy. Nope. They claim that all the time. What? Dustin's got the right idea, man. Leave those chicks at work alone. At least wait until you quit. Or if you love her that much, just quit. Dang. You get one chance to ask respectfully. Everything after no is a harassment. Dang. That's crazy. All right, let's get into this next one. Oh, we got some more news about what's going on here in Fulton County. I know Fulton County. It's always something going on here. If y'all haven't heard about this, this is insane. I guess this is breaking news. This story broke less than 12 hours ago, which I don't know. What's the rule? What's the rule on breaking news? Does it have to be within the hour? We'll call it breaking news anyway. Either way, recently, 3 detention officers right here in Fulton County have been arrested because of misconduct at Fulton County Jail. Shout out to Atlanta News First. They've got the full report, and then we'll get into an article by News 2, which breaks it down a little bit further. Check it out.
Evidence of inmates mistreated, investigators say. Tonight, their accused attackers are in jail themselves. Atlanta News First reporter Bridget Spencer live outside of the Fulton County Jail. And Bridget, this incident is yet another dark cloud hovering over this heavily scrutinized facility.
It really is, and tonight we've read through these warrants and we uncovered more details about these accusations. Now, these detention officers, they've been working here and they've been accused of tasing and even shoving multiple inmates here, and now tonight they find themselves behind bars.
Come on, man.
3 Fulton County detention officers now in serious trouble, facing charges of aggravated assault and violation of oath. The arrest warrants obtained by Atlanta News First say Khadijah Solomon and Chantrice Buggs were arrested after a compliant inmate was tased 3 times. Solomon is also accused of trying to cover it all up. A separate warrant says LaQuandria Pierce shoved and tased a different inmate while he had his back turned. Investigators say an act of willful inhumanity was committed against both detainees. In a statement, Sheriff Pat Labatt says, quote, "These arrests are part of an ongoing effort to uphold professional standards and ensure the humane treatment of all residents in our custody."
Y'all think these are the only ones, or did they just get thrown under the bus? I don't know. Patrick Labatt's in there trying to clean house and get the DOJ off his back, so we'll see.
Professional standards and ensure the humane treatment of all residents in our custody. Fulton County Commission Chairman Rob Pitts now speaking out tonight.
It should not have happened.
This is yet another scar on the embattled jail that has been recently called out by the Department of Justice for housing inmates in unconstitutional conditions.
In the report that the Department of Justice did, they were concerned about the treatment of inmates. And we are concerned here, so we're going to address that.
Last month, the feds, the sheriff, and the county reached a legally binding agreement to fix the issues at the jail.
We're both in it together, and he and I signed this consent decree back in January, so I'm ready, to, so to speak, to get the show on the road.
Chairman Pitts says this situation highlights how important training is for all jail employees. He hopes
Here we go with the
can
training
remember
again.
that each inmate at Rice Street still has rights.
These are human beings. They may have made a mistake, maybe not have made a mistake. They may be innocent in our care.
That's true.
And in that consent order, a monitor is supposed to be hired to basically look over the shoulders of employees and commissioners and make sure that they are abiding by that consent decree or that consent order. Now, Chairman Rob Pitts says by the end of the week, they expect to have their recommendation on who this monitor is supposed to be, and that's something we are going to be following closely. We're live from the Fulton County Jail. Bridget Spencer, Atlanta News First.
Tonight.
Yeah, it'll be interesting to see what happens with that, too, because I can't imagine who they're going to put in place. Fulton County already owed this other company that was there millions of dollars and weren't able to pay them. So we'll see what happens moving forward with that. Let's get into a little bit more details. We've got a quote here from Patrick Labatt, too, speaking on it a little bit more. Shout out to News 2 for this article. They say the Fulton County detention officers face charges of mistreating inmates. The 3 former Fulton County detention officers who worked at Rice Street Jail are under arrest and facing multiple charges after a misconduct investigation revealed that they mistreated inmates, officials said. What happened? These arrests are part of an ongoing effort to uphold professional standards and ensure the humane treatment of all residents in our custody, said Sheriff Patrick Labatt. He also says the sheriff's office has reaffirmed its decision to enforcing strict policies against misconduct and has vowed to continue working towards reform that improves jail conditions. Well, they don't have a choice because, as mentioned before, the Department of Justice is going to make sure that that happens. On Tuesday, Channel 2's Michael Seaton, shout out to Michael, confirmed exclusive details about the 3 women who waived their first court appearances following their arrest. Detention officer Sergeant Solomon, 47, is charged with 1 count of aggravated assault, 1 count of cruelty to inmates, and 1 count of false statements or writing, and 3 counts of violation of oaths by a public officer. Jay, I want to see that indictment. Detention officer Bugs, age 50, is charged with 1 count of aggravated assault and 1 count of violation of oath by a public officer. Detention officer Pierce, 38, is also charged with 1 count of aggravated assault and 1 count of violation of oath by public officer. It remains unclear if they have retained attorneys. Investigators arrested the 3 women after reviewing body camera footage of 2 separate incidents involving 2 different inmates. I'm gonna have to see if I can find that too. In the most recent incident on February 13th, the arrest warrant stated that Pierce can be seen walking with the inmate in handcuffs. When the inmate stopped walking, Pierce was seen shoving him and ordering him to walk in a different direction, the warrant stated. The inmate asked Pierce to stop shoving him, but then the situation escalated. The inmate then turns his back to detention officer Pierce, at which time she deployed 1 cartridge from her department-issued taser, striking the inmate. Dang! According to the affidavit, the inmate appeared to be suffering from neurological incapacitation and falls to the ground while handcuffed, by the way. It's unclear if the inmate suffered any injuries. On January 16th of this year, investigators reviewed body camera footage videos captured by Solomon and Bugs. In the video, Solomon is heard saying, I'm about to pop his ass. You know what she said. Come on. As she uses a key to open the cell door of an inmate, according to the affidavit. The video showed the inmate standing in his cell holding a tray when Solomon deployed her stun gun, striking the inmate, who is seen falling to the ground, investigators confirmed. She can be heard screaming at the inmate in the footage. You just broke the something expletive glass. Put your hands behind your back, she said, according to the affidavit. The inmate complies with the officer's order, and she deploys her stun gun for a second time, according to the affidavit. She ordered him to get up again, and body camera video captured her deploy it for a 3rd time, investigators confirmed. God, dang. Solomon filed an incident report in which she claimed that the inmate was angry and began kicking around glass until it shattered, investigators said. In an interview with investigators, the inmate told them that he was upset because he couldn't get a haircut. Oh my gosh, man. Y'all stay out of this system. So we're going to stay up to date on this story. I'll give y'all any news and maybe we can get the body camera footage and I'll play it here for you or I'll post it on the YouTube channel. Let me know what y'all think about this. Is this just the beginning of a long series of arrests that are going to be made because of misconduct in Wright Street? What do you think will happen to these detention officers? Let me know in the comments and in the chat. Sheesh, man. Fulton County is a mess right now. We got a lot of work to do. There's a lot of good things and there's a lot of things that need to be fixed too. Oh man, about half of U8 states allow lawsuits for breach of promise to marry. These states include Hawaii, Mississippi, Missouri, New Mexico, North Carolina, South Dakota, and Utah. Insane. They look like they bite, says Danny. Where's Fanny with the charges? Yeah, Fanny, she's coming up next for sure. Wonder what happened to the ones that were bringing in pot pies and cell phones. Oh my gosh, of course it's unclear. Just the beginning of the end. Yeah, I agree. Shocker, says Michi. I know, this is not surprising at all. I know someone who had a breach of promise to marry lawsuit. He lost too? Dang! Are you serious? Kiana, you got to tell that story. I want to know what happened there. I might have to open up the phone lines coming up here soon. I don't believe... Oh, you're talking about A$AP Rocky's trial. I don't believe it was a real gun. I think if it was, Relly would have been shot. He also would have followed him... Wouldn't have followed him around the corner... Wouldn't have followed him around the corner, putting his life in danger. No Jumper called Relly on the phone and told him he was on live. He promptly hung up the phone. Oh, dang. Oh, man. Vivi says you've never seen me do phone lines before. Yeah, we did it. We did it a couple months back. We might have to start doing that again. They just need to knock that jail down. Nothing good about this jail. They didn't get thrown under the bus. They got caught. I bet it's not their first time either. No, I highly doubt it. You don't develop this type of culture without them, one, seeing somebody else doing it, and two, without letting it happen over and over and over. All right, y'all. I'm gonna let y'all get up out of here. Thank you again to everyone that showed love. 100% of y'all liked the video so far. Thank you so much. If you haven't yet, subscribe, hit the notification bell so you don't miss any time that we go live. We will be here every single weekday, so you don't want to miss out. We'll be back tomorrow around the same time. We'll probably be here about tomorrow around 10:30. So y'all make sure you stay tuned so you don't miss any time we go live. Also, tune into the show tonight, 8 p.m. Eastern Standard Time. We got a versus challenge for you for the Song of the Night Live. You all will get a chance to vote and decide which artist is going to get that next spot in the season 11 tournament. All right. Other than that, I hope y'all have a great rest of your day. I appreciate you, and you know what to do. As always, keep growing, keep pushing, keep it classy. We gone. Peace.